All right, in this particular lecture, we're going to focus on constitutional clauses. Now, what a constitutional clause is a segment, phrase, or word, whatever section of the Constitution that has some sort of importance in terms of legal definition. So when we talk about constitutional clauses, we are talking about the clauses of the Constitution or the phrases in the Constitution that we use to define certain concepts or certain legal concepts within this course. So what I've done in here is I've only focused on the main constitutional clauses. So these are the ones that you will need to be familiar with, not only for a multiple choice, but also for short answer. And some of them we will discuss a lot in more detail later. But I will just go through all of them right now so that you know kind of what is expected of you when it comes to these sorts of clauses and information. The most important thing that you will need to know for each of these is you will need to know their general location and also their meaning. So when we talk about the first one is the supremacy clause, and it is the statement within Article 6 of the Constitution. You do not need to know the Section 2 part, but you do need to know Article 6. Supremacy clause states that this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made shall be the supreme law of the land. So what this particular clause in the Constitution says is that any federal law is going to supersede state law. So any law that Congress makes cannot be in conflict with any state law. So if there's ever a conflict between two laws, we will defer automatically to the federal law. So the Constitution itself is the supreme law of the land. There are a couple of cases where this has been challenged, as you will see throughout the beginning of this course. And ultimately, the courts tend to side with the federal government when a case like this arises. So the first clause is the supremacy clause. Again, it is in Article 6 of the Constitution. The second clause is the necessary and proper clause. The necessary and proper clause is in Article 1, Section 8 of the Constitution. Again, you only have to know that it is in Article 1. This one pertains explicitly to Congress. This one says that Congress shall have the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. And then it lists all of the powers that they have. So things like printing money. Within the necessary and proper clause, we have seen an increase in the powers going towards the federal government. The vague nature of this clause has kind of increased those powers. So if we take the example of Congress being able to print money, nowhere in the Constitution does it say that we are allowed to have a Federal Reserve. It does not say that we cannot have a central bank. It doesn't say that we should have somebody that is kind of watching over all of the printing of the money and making sure that inflation is under control. However, because of what it says in Article 1, where it says that they can make all laws necessary and proper for carrying out the execution of these powers, because they have the power to print money, this clause has given the Congress and the federal government the ability to create an institution like the Federal Reserve that allows for a monitoring of the circulation of money. So this is just one example. We will talk about a couple of more, especially when we talk about federalism and things like that. But it's just one example of how the necessary and proper clause can lead to increased national power when we talk about the federal government. But ultimately, it kind of leads to Congress maybe taking over some roles or some jobs that they maybe aren't necessarily explicitly stated in the Constitution. The third one is the Commerce Clause. Again, this one is in Article 1, and it states Congress has the power to regulate commerce with foreign nations and among the several states. And when you see that phrase among the several states, what they are talking about obviously is the 50 states within our union. So if there's an issue of some sort of commerce going between Kentucky and Ohio, the Commerce Clause would be the authority of the Congress or the federal government to step in on that issue. This one is kind of near and dear to our heart in northern Kentucky because of something like the Brent Spence Bridge. That is one of those where it does have to do with commerce going across the country. It's one of the most populated bridges, or one of the most heavily driven bridges in the country on a daily basis, and it needs to be repaired. The question that we often have is, who is responsible? Is it Kentucky or is it Ohio? Because of that conflict, the Commerce Clause would be able to give the power to Congress to regulate kind of what happens throughout this process. So again, it increases federal power, gives that power to the federal government to kind of supersede the states again. But this one is only in regulating the commerce or the business dealings between the states, and then obviously with foreign nations. The next one is the General Welfare Clause. You probably won't see this one too often on the AP exam, but I do throw this in here just so that you have an idea of what kind of another way of how the federal government can kind of increase its power. In the preamble of the Constitution, very early on, it says, "We, the people of the United States, in order to form a more perfect union," and then it goes down and says, "promote the general welfare." This is one that I think kind of shows the difficulty in understanding the Constitution and what the powers are that should be going to the federal government or the state government or the Congress or the president, because the term general welfare means something different to each individual person. When you say promote the general welfare, some people might say that means that the federal government has the ability to create a public school system. Other people might say that promoting the general welfare would be implementing a national healthcare system. So all of these kind of show you the ambiguity, if you will, of these phrases, and how oftentimes politicians will use them to benefit their particular political agenda. But the General Welfare Clause is in the preamble of the Constitution, and kind of also gives some power to the federal government. The 10th Amendment is important, especially when we talk about in the next chapter federalism, because it's kind of the clauses that you just saw within the Constitution combating with the 10th Amendment for power between the states and the federal government. The 10th Amendment states that all powers not specifically stated within the Constitution are reserved to the states. So someone that is a fan of the rights of states making their own decisions are going to look at things like public education, healthcare, elections, all of these kind of different things that they are not stated within the bounds of the Constitution. According to the 10th Amendment, those would be reserved to the states. So the states would be responsible for public education. The states would be responsible for a healthcare system. The states are responsible for holding elections. And in fact, all three of those, in some form or fashion, to some degree, are a power of the states. And obviously, some of those other clauses have kind of encouraged the federal government to step in on some of those issues. But the 10th Amendment does kind of contradict some of these other clauses within the Constitution, and they increase some of the powers going to the state government. The full faith and credit clause is in Article 4 of the Constitution, and it basically states that the full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. This one will probably not show up. I say that, and obviously we hope that I'm right, but I don't know what the exam is going to look like at the end of the year. But this one, the full faith and credit clause, is just an important concept to understand. When a state issues some sort of license or some sort of public record or public act some sort of judicial proceeding. All 49 of the other states are now required to recognize that. And a good example is going to be a birth certificate, or a marriage license. Somebody who is identified as a married couple within one state is automatically going to be recognized as being married in another state. And this was challenged, obviously, with an issue such as gay marriage, where someone originally could have been married in the state of Massachusetts, but that maybe didn't apply to a state like Kentucky. That has since changed. And a good example that would be very familiar with you guys of the full faith and credit clause would be if the state of Kentucky issues you a driver's license when you go and drive into Cincinnati. They recognize the fact that since Kentucky has given us the right to drive, they too give us the right to drive. The same thing in Kentucky. I believe Ohio might have a younger driver's license. So in Ohio, if you're 15 and a half or whatever, and you're driving in Kentucky, you're not going to get pulled over if you're following all of the laws of Ohio with having somebody in the car and things like that. So if they've issued a permit or whatever, full faith and credit clause is going to be that the other states are going to have to recognize that legal proceeding. Again, this one will probably not show up on the AP exam, but I do think it's just something good to know going into some of the other conversations that we're going to have. These next couple of, I think 3 or 4 clauses will be coming later in the course, but I just wanted to have them all in one place for you right now. These are going to come more in Unit 3 in the second semester when we talk about the civil rights and civil liberties. The first one is the Establishment Clause, and the Establishment Clause is a part of the First Amendment. It's the phrase very early on that says, Congress shall make no law respecting an establishment of a religion. So Congress cannot make a law that is going to push one religion over the other. And the second one that kind of goes with this is the Free Exercise Clause, also within the First Amendment. And you'll see kind of how I wrote this here. And this is how it is written. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise of. So the establishment government, the government cannot establish a religion, but the government also cannot stop the free exercise of a religion. And what Thomas Jefferson called this was the separation of church and state. Again, we will go into these a lot more, but when we get into Unit 3, you will have to know cases, Supreme Court cases that apply to each of these clauses and how these clauses have been interpreted over the course of especially recent U.S. history. Things like public school, public school busing to private schools, and textbooks being purchased in private schools, and prayer in school. Those are some of the topics that we'll be talking about when we get to January and discussing these clauses a little bit more. The Equal Protection Clause is in the 14th Amendment. We will be talking about this when it comes to the issue of racism and the interpretation of the Supreme Court and how this particular clause within the 14th Amendment has been interpreted over time. The Equal Protection Clause states that no state shall or not deny any person within its jurisdiction the equal protection of the laws. This obviously was interpreted much differently in the early 1900s as it is today. And we have become much more inclusive when it comes to this sort of clause within the Constitution. But again, we will be discussing this within the context of the Civil Rights and Civil Liberties Unit. And the last clause that I think is important to know when we go into this course is in the 14th Amendment again, and it's the Due Process Clause. The Due Process Clause states that no state can deny any person of life, liberty, or property without due process of law. What this is going to open up is the idea of interpreting the Constitution to apply to the states. We'll get into that a lot more again in Unit 3, but I just wanted you to be familiar with the language here so that you can maybe have all the clauses in one spot. These are the kind of the big ones that you would need to know for the AP exam. That is it for this particular lecture. If you have questions, first go back and look at the PowerPoint and make sure that you understand exactly what was said. And if you have any other further questions, be sure to ask them either in a class or you can send me a message whenever you get a chance.